Zachary Rehl, defendant in the Proud Boys trial, files a motion for a mistrial and a motion to dismiss his obstruction charge. The motion for the mistrial is based on this idea that Zachary Rehl is not like the others. Which one of these things is not like the others? Which one of these things just doesn't belong here? Carmen Hernandez, the defense attorney representing Mr. Rehl, who you see here, is saying that he was not violent. He wasn't even involved in many of these conversations. He was not even involved in many of the physical locations, and saying that if you want to make sure that he's involved in a conspiracy, which is what they're being charged with, seditious conspiracy, you got to have some sort of independent evidence that establish him as a part of the conspiracy. He's got to be independently verified as a conspirator. You can't just say, well, all of these other guys did something and you were kind of like near them and therefore you're a part of the conspiracy. You got to show that he took some sort of volitional action. He did some things that put him in with the rest of the group. And thus far throughout the trial, there hasn't been much that they have shown. So let's take a look at these two different motions. The first one came in. This is the motion for a mistrial. Shorter filing, 5 pages. USA versus Zachary Rehl. And this was filed by Carmen Hernandez. This is a motion to strike out-of-court statements and declare a mistrial, saying that it is now appropriate, Judge, after what we have seen take place in this courtroom, to strike, eliminate, remove Parler, Telegram, and other messages that this judge conditionally admitted by the court on the basis that the necessary factual predicates for their admissibility have not been met. So this is a little bit of a technical argument, but she's saying the judge allowed certain statements to come in on the basis that something else would be proven, and that other thing was not proven. Therefore, the statements that came in got to go out. And if you don't do that, if you don't throw those out, well, actually you do have to throw them out and declare a mistrial, because those statements that you allowed in were so damaging that this trial is irredeemable. Nothing can be salvaged. The defense says, as the prejudice from the extensive materials that were introduced cannot be cured, we now move for a mistrial. Now, this is a little bit technical, but it is interesting. They say that there is a conditional admission of evidence standard. And when you have co-conspirators, in this case, you've got co-defendants, 5 Proud Boys, they say that they were going to engage in seditious conspiracy to take over the country. Certain statements that are hearsay can be admitted under the rules. The judge, in his discretion, may permit the introduction of things that were said and done by alleged co-conspirators, but the court may strike the testimony if it has not been sufficiently connected to the rest of the case. Because you can't implicate somebody by just saying they were loosely affiliated with a broader conspiracy. You need more direct evidence. And so she's saying, Judge, we're asking you here to dismiss. In the instant case, this court rejected our suggestion. The judge let the evidence in on the presumption that the underlying condition would be met, and it wasn't met. The judge said, well, the better practice is for the court to determine and make a ruling in a different way. And so she's referencing the rules. She says here, the court must make 2 independent decisions. And in the instant case, the government has failed to do that. There is no substantial independent evidence of a conspiracy, writes Carmen. There's no evidence of Mr. Rehl's participation in one. Neither Bertino nor Green, 2 other people, the 2 cooperating witnesses who testified that they were aware of any agreement to commit a seditious conspiracy, nor were they aware of Mr. Rehl's involvement in them. Bertino nor Green, neither of them testified to being aware of any conspiracy to corruptly obstruct the proceedings. And Green did not know and had never spoken to Mr. Rehl. He was acquainted with Mr. Pizzola only slightly. He traveled to a car in D.C. with another person. He was not even a Proud Boy. Green indicated he knew of no plan, no agreement to come to D.C. to commit a conspiracy. He owned small weapons. He didn't bring any of those weapons with him. The insurrection without massive troves of weapons. While in D.C., he said he acted spontaneously, just as things developed. Similarly, Bertino did not indicate that he had ever spoken with Rehl about these conspiracies. Nobody was talking about it. And although he was close to Tarrio and spoke with him on January 6, Bertino knew of no plan to attack the Capitol. No other person testified to being involved with any of the conspiracies. The only evidence that was introduced were statements that were conditionally admitted by the court, but which the court can't consider unless it's supported by substantial independent evidence. And because the government has failed here, a mistrial is warranted. When the government fails to prove the existence of a conspiracy by providing that independent evidence, it must give the jury a curative instruction. In this case, these out-of-court statements were so extensive, it's all inadmissible hearsay, and therefore the court must declare a mistrial. From Carmen Hernandez, representing Zachary Rehl, good motion. Now we'll see what Judge Kelly does about that, and the judge will wait for the government to issue their response. But this was just one of two motions that Ms. Hernandez filed. The other motion was a motion to dismiss based upon the Court of Appeals ruling. And I want to cover this briefly before we jump into the trial. But this filing is a motion to dismiss just that one single count, the obstruction charge. She says that there's an appropriate time now to bring this back up. Says that historically, the court denied a very similar motion when we filed this the first time. You denied it again when we filed it a second time. But now we're filing it again. Why? Because the Court of Appeals has issued a ruling. And if you read it carefully, they're saying it requires dismissal of the obstruction charge. Now, we read through this full opinion, not the full opinion, it was quite long, but we skimmed through the majority and the dissent, and we really gleaned over the concurring opinion. But the concurring opinion is being latched onto here because the concurring opinion says that they join Judge Pan's opinion only conditionally, but if the condition is not met, then he would join the dissent. Okay, so it's a very weird concurring opinion. You don't ever see concurring opinions like that. This concurring opinion sounds like it's not really a concurring opinion. It's like a conditional. If this, then with the majority, but if not, then with the dissent. And so we're sitting here going, well, gosh, that's kind of a predicament because the thing that you're considering a conditional is kind of the reason we're in your court right now. Kind of need you to decide that. You know what I mean? So pick a side. And we flipped over that, but apparently he didn't pick a side. And so we don't actually have a ruling on it. Go figure. So Judge Walker also posits that his opinion should control because if the unmet condition that he places in his concurrence, they say that Judge Katsas, the dissent, is the only opinion that receives 2 votes because we can't decide what the opinion was. So we don't really know what the ultimate Court of Appeals ruling was. The defense is making an argument here that there is no clarity on this, and because there's no clarity, you got to default towards the dissent. The majority opinion, in fact, is not the majority opinion. They say the dissent is clear that the conduct only covers conduct that impairs the availability of the evidence. And we were asking ourselves specifically about what type of conduct was prohibited in these charges. And as we talk a lot about here, there are checkboxes that you have to check in a criminal charge. And you go through the list. So, were they in the Capitol building in a place they shouldn't have been? Do they have identification? Did they obstruct corruptly something? Well, you ask yourself, what does obstructing mean? What does corruptly mean? And you're breaking down this phrase. What does impairing the integrity and the availability of evidence mean? And so we went through a lot of the analysis on this. A lot of word games were being played. But when we fast forward through it, the defense is saying, you can see here copying large portions of the opinion and saying that the narrow reading of corruptly was a necessary condition to his vote. And because we can't prove that that condition has been met, the obstruction charge must be dismissed because we don't actually have a full vote because we can't prove that the condition has been met. So another very interesting filing from Carmen Hernandez. We'll see what she's asking for here as we fast forward to the conclusions. Wherefore, Mr. Rehl respectfully requests this court reconsider its decision, dismiss counts 2 and 3 of the indictment, calling them unconstitutionally vague and in violation of Zachary Rehl's rights to a fair trial. Signed by Carmen Hernandez, defense counsel for Rehl. So 2 big filings there for Zachary Rehl as well. We'll see what Judge Kelly starts to rule as the trial continues.